Hello everyone, this is Shiv, Prem, a legal intern at LEXIS and Company and currently pursuing BLLB honors from Central University of South Bihar. This is the second video of today's session. In the first video, I had dealt with the doctrine of public accountability, where I had discussed the meaning of accountability, the meaning of public accountability, the doctrine of the public accountability, and I had lastly dealt the evolution of that doctrine. In this video, I will be dealing with the need for the doctrine, that is the corruption, and RTI as a tool to enforce the doctrine. So let us start the need for the doctrine. Public corruption is as old as public administration itself. While countries endeavor to become social welfare states, it has inevitably resulted in the expansion of bureaucracy in size as well as in number. This expansion has consequently resulted in a huge amount of work for administrative authorities and the application of their discretion and power. It is an age-old tale. Discretion and power always bring with the possibility of their abuse. Now let us see RTI as a tool to enforce the doctrine. Absence of participation by the general public can be attributed to lack of information about the government process. The Supreme Court, while giving opinion in the case of SP Gupta versus the President of India 1981, on the importance of an open government, said that the demand for government's openness is grounded in the reason that the exercise of their right to vote, choosing their leaders for the next 5 years and then returning into passivity without any interest in the government is not what democracy is. In 1975, during the case of Raj Narayan versus the state of UP, Uttar Pradesh, the court held that secrets must not be exist in a government where agents are held responsible for their conduct. In 1982, during the SP Gupta case, the court elaborated on the positive trend of liberal democracies moving towards an open government and how India should be no exception to this new democratic culture. In 1997, in the case of Dinesh Trivedi versus the Union of India 1997, it was held that to secure participation of the general public in the democratic process, vital decisions taken by the government should be conveyed to them at the basics thereof. The Supreme Court judgment in the Raj Narayan case of Right to Know in 1975 to the enactment of the Right to Information Act in 2005 has come a long way. The passage of this act made a way for a new administrative culture and provided a boost to democracy. The Chief Information Commissioner of India held the legislation and as outstanding and unprecedented as the response of the public. The landmark legislation of the RTI Act has all the central, state and the local governments and the public authorities under its ambit. It also has applicability to the judiciary and the legislature. Information has been defined as including the right to inspect work, documents and records that are held by the government and also permits the extraction of certified samples for verification. Over the years, there have been many appeals to amend the law to allow the refusal of information that is irrelevant to the applicant. However, the refusal to information is not the answer. Proactive disclosure can prove to be a highly positive step. The RTI Act in itself has its basics of the principle of maximum disclosure and minimum expectations. That is, revealing almost all information and making an exception in cases where the information is absolutely necessary to be kept confidential. While government offices are flooded with frivolous applications, the way to deal with this is to make the information available for the public domain voluntarily. Rather than crushing the exposure of the RTI Act, the public officials should treat it as an allowance of expression of opinions and as a shield against the claim of manipulation. RTI is continuously proving to be an effective tool for tackling corruption. Achievements of those like the civil society organization Parivartan in Delhi wherein they collected information about the flow of public funds, is the best illustration of how information can be used to hold the governments accountable. However, it is evident that more work needs to be done. In a report by Transparency International, if India was to reduce corruption to the level of Scandinavian countries, there would be a 12% increase in the investment and 1% 5 per annum growth rate in the GDP. So, the task of the government does not come to an end after creating illustration, institutions, laws and measures. It's when the real job of making sure these laws are effective starts. The Indian judiciary has been proactive in the area of public administration and the evolution of this doctrine. However, if corruption is not tackled with the proper accountability for execution of roles, it becomes a long-lost dream. By passing legislation such as the RTA Act 2005, the government has illustrated its intentions to establish a good governance. However, a lot still needs to be done to ensure effective application of this act, and that comes with public officials taking a step forward to ensure the rightful usage of the taxpayers' money and transparency of government. A small steps such as implementation of performance appraisal mechanisms for honest officials can go a long way to incentivize the other officials to follow suit. So that's all for now. Let us meet in the next session with a different topic, and please do like and subscribe the channel. Thank you.